Suffolk County DA Rachael Rollins has never been one to shy away from controversy. She was elected by a landslide, campaigning on a platform centered on major criminal justice reform. And since her election, Rollins has kept that focus front and center, but with a new battle at nearly every turn, often waged by her own colleagues. And the latest has turned pretty ugly. It centers on a case Rollins is pursuing involving a man who took part in the murder of 16-year-old Javon Blake back in 2011, having supplied the gun and identified Blake as the target. Both that man and the shooter were convicted of first-degree murder, but because the shooter was 17 when he pulled the trigger, he's eligible for parole after 15 years. But the other man, who was 7 months past his 18th birthday, less than a year older than the shooter, will never be eligible. So, Rollins is pushing for a law change to allow an 18-year-old, possibly even someone as old as 21, to get the chance for parole with a first-degree murder conviction. And while some fellow DAs support her move, others do not. But here's where things get messy. Instead of filing an amicus brief, which is the usual way disagreeing players will weigh in, Cape and Islands DA Michael O'Keefe, Essex County DA Jonathan Blodgett, Norfolk County DA Michael Morrissey, and Plymouth County DA Timothy Cruz asked to join the case as interveners to offer their own evidence against Rollins' argument, a move that frequent guest and former federal judge Nancy Gertner called insulting and over the top. And in her response to that, Rollins did not hold back, writing in a court filing, "This motion is nothing more than a misogynistic wolf in sheep's clothing. Never has this court allowed one, let alone four, elected district attorneys to intervene in another DA's matter." She goes on to note, "These four men are not parties, nor can they be parties in this case. The party in the case is the Commonwealth, represented by District Attorney Rachael Rollins, the first female District Attorney of Suffolk County, and the first woman of color, black, to serve as District Attorney in the history of the Commonwealth of Massachusetts." I think you maybe see what she's getting at there. And in response to that, in an email to the Globe, O'Keefe said, quote, "There are policy differences here, but it's become increasingly clear that if you don't agree with District Attorney Rollins, you are called a racist or a misogynist or both." Ultimately, by the way, the SJC did deny the four DA's efforts, but when invited to join us tonight to defend their position, not one agreed to appear. Fortunately, the Suffolk County DA did. Rachael Rollins, thanks so much for being here.
How are you, Jim?
I'm good, thanks. What's your argument for why an 18 to 21-year-old, having committed the worst of crimes, should ever have a chance of getting out of jail?
Well, first of all, this office, Suffolk County DA's office, convicted Mr. Watt and Mr. Mattis and filed an appeal holding up their conviction to the Supreme Judicial Court. So we have stood by the family of Mr. Blake, who are the victims in this case, during this horrific ordeal. However, as the DA, Jim, I have to believe that there is A, in science, and B, that people are capable of redemption. You just did an introduction telling us that Mr. Watt, who we all know pulled the trigger, was just shy of his 18th birthday. He's going to be parole eligible after doing 15 years. Mr. Mattis will never be able to appear before the parole board. And I think brain science makes it clear that you don't stop developing the day you turn 18.
You mentioned Mr. Blake's family. Did you reach out to Mr. Blake's family before you decided to seek this change?
Well, remember, the SJC actually ordered us to create an evidentiary record so that they could look at the Diachenko standard, which they had determined maybe 6 or 7 years prior. So we did not ask for this, Jim. This was a situation where the SJC is asking us essentially, we asked for the convictions to be upheld, and they're asking us to create an evidentiary record. Of course, we reached out to the family of Mr. Blake, as we do in any circumstance. They are the victims in this case. So they are aware that that there's going to be a hearing. They are also aware, Jim, of the fact that all this does is give a potential glimmer of hope to somebody. The parole board has to make a decision, of which I am not on, neither are any of my peers.
Did they say they supported what you were doing in this case?
So we reach out to them. I'm not certain that they support what I'm doing. All we are doing is creating an evidentiary record, Jim. The SJC gets to decide, like they did in Dianchenko, to say it is unconstitutional for a juvenile to spend the rest of their life without the possibility of parole. But they will be deeply involved. And Mr. Blake's family, Jim, when Mr. Watt goes up for parole, will be able to be heard by the parole board, because remember, he's 17.
Now, I read some of the statements you made in your pleadings. Let me add one. This is from you. The suggestion that their assistance, those are the 4 other DAs, is required is as misogynistic and paternalistic as it is racist. They said in a statement, all we wanted to do was ensure that certain scientific evidence got in the record. Why do you discount their argument? Why do you make the conclusion that you do about their desire to intervene, DA?
Because when Dianchenko was decided some 6 or 7 years ago, and I was just a happy person that had never even thought of running for DA, and these 4 men and my predecessor had been multi-term DAs at the time, none of them intervened into that Suffolk County case. None of them told Dan Conley, hey, step aside, son, we have this, which is essentially what they're claiming with respect to me. And what I also wrote, and these were my fingers that wrote it, query, what is it about District Attorney Rollins that makes these men so unsure as to what I can do with respect to my cases? Jim, this is an evidentiary hearing in a superior court case. There are mechanisms by which other people can be heard. Amicus briefs are filed all the time. If the judge doesn't think we're doing a good enough job, a judge could actually ask for other people to come in and hear testimony from them. But to imply somehow that the exceptional assistant district attorneys in my office, mind you, my chief of appeals, that's a woman, my deputy chief of appeals, that's a woman, my general counsel, that's a woman, we are doing quite fine here. I think there are hate crimes to be investigated into on Nantucket or other things that they could be busy doing that they haven't done for years.
You think if you were a white guy DA, they wouldn't be doing this? That's the bottom line,
I think
right?
they would have, no, Jim. I think they would have picked up the phone and called and said, what are you doing, a DA so-and-so? What I don't appreciate is them not paying me the courtesy that I pay them all the time. I picked up the phone and told one of the district attorneys while he was on vacation that there was an officer-involved shooting that left my jurisdiction and entered into his. I pick up the phone and tell other district attorneys when errors are made when they enter into my district that we are getting media calls and I'd like to speak to their media person so our statements are aligned. That is how you lead. I told you, I've called U.S. Attorney Lelling when we filed ICE. I called Chief Lyons when we filed ICE. That's the way that you operate with each other. It's completely disrespectful to the people of Suffolk County for them not to pick up the phone. And I'll end, Jim, with the president of the Mass DAs Association, Anthony Gallooni, actually did pick up the phone and we had a conversation about this case. He had questions about it, and I said that before we filed anything, we would keep him in the loop. And that is what peers and colleagues do with each other. They don't file at a lower level or tell an entry-level employee what they're going to do.
Can we move to another initiative that you're part of? It's actually a national movement to essentially bring truth, justice, and reconciliation commissions that are modeled on what we've all read about and learned, I hope, about in South Africa to the United States. To what end? What would the purpose of such things be if they were to be implemented in DA's offices, in criminal justice systems, District Attorney?
So we are one of 3 locations in the United States that were selected for a pilot program: San Francisco, Philadelphia, and Boston. And what I had said, Jim, is that until we can reckon and atone for our past, we are going to continue making the same mistakes as we have. When we see places like South Africa or Germany, even Canada with some of the indigenous people there, Guatemala, and then within the United States, we've seen it in North Carolina and Virginia. These Truth, Justice, and Reconciliation Commissions have been successful in some instances and then have left people re-traumatized, actually, when they haven't worked in certain circumstances. I think for Boston, Jim, when we look at a busing, when we look at a Charles Stewart murder, there are brands and stains and blemishes on our city, which is a great city, that I think we still need to atone for. And then individual harms that people have. What it does is it mends relationships between communities and law enforcement. And ultimately, Jim, that is going to help us solve more crimes, because when people feel listened to and heard, they are more inclined to partake in the process.
So is this actually going to happen here, or is this just a concept?
No, it better happen. Yeah, it's what we are told is that I'm hoping after the first of the year, we're going to start really putting some things together. But I intend in the weeks to come to have some listening sessions to speak to the community about what this could be. My office is going to be the conduit through which the money comes, as are the other two DA's offices. But I think we need deep and consistent community involvement in order for this to be successful.
We only have a minute left, and I wanted to broach something with you that you may not be totally up to speed with, because it was in the Senate bill on police reform that passed in the middle of the night last night. They did not eliminate qualified immunity, which I know is a position that you support, the basic protection from officers in almost but the most egregious cases from personal liability. But there's an element in this that mystified me, and I wanted to get your quick reaction. In the statement from the Senate President explaining what they did, they said she said the bill also makes clear that nothing in this bill impacts or limits existing indemnification protections for public officials, meaning that a city or town can assume the financial risk and indemnify an officer. Even if the officer is sued, it's allowed to proceed, and he or she is found liable for having violated the rights of an individual. Do you support that indemnification concept? Doesn't that undercut the whole notion of personal liability?
I agree with you. I'm not supportive of that. I was not in the discussions up until early this morning with the Senate. But, you know, what I think we find ourselves at, Jim, is we have the Senate now has voted, I think, 30-7. It's going to go to the House.
Yeah.
But we also have 4 collective bargaining agreements right now, Jim, with the Boston Police that are all up for renegotiation. We have a mayoral race that is happening as we see it, and a Boston City Council that is moving for change, whether it's Councilor Edwards or Councilor Campbell. I think we're going to see significant changes, and I think, you know, I'm watching with bated breath to see what happens with the House. But I think we need some form of change with respect to qualified immunity.
Rachael Rollins, thanks so much for your time. As always, good to see you.
You as well.